Hi, Nan Jensen here. This is video number 2 in the Preparing for Adulthood series, and the topic is the Convention on the Rights of Persons with Disabilities and Supported Decision Making. Before I get started, I have to go through my disclaimer again. So this is the disclaimer. These videos contain information. They do not contain legal advice. If you need legal advice, you need to speak to a lawyer. You need to tell them your entire situation, and they need to give you a letter of engagement. So this is not legal advice. You should not rely on anything you hear in the videos. This is just information. Okay, so the topic of this video is the Convention on the Rights of Persons with Disabilities and Supported Decision Making. Now, I mentioned in video number 1 that there's some people who don't like the Protection of Personal and Property Rights Act because they believe that it takes away rights. And now I want to talk about the Convention on the Rights of Persons with Disabilities because that gives some understanding of why people feel that way. The convention is a UN convention. It's been signed and ratified by New Zealand, which means that New Zealand has committed to incorporating the principles of the convention into its own laws. Now, the convention is a really important document, and it's a really good idea to Google it and look at it. I'm not going to talk about it in great detail, but I want to address Article 12, which is about the right to self-determination. And this article talks about the fact that supported decision-making is the appropriate way for disabled people to have decisions made, and they should not have their right to make decisions for themselves taken away. So, supported decision-making, if you remember, is about having somebody support you to understand the nature and consequences of a decision so that you can make your own decision. The PPR Act, as we have mentioned, the Protection of Personal and Property Rights Act, allows for substitute decision making. And so this is why people aren't happy about it, because they believe that that act does not have supported decision making. The government, at least the previous government, and this one I assume as well, because the act still exists, claimed that the principles and the objectives of the act show that the act actually contains supported decision making. So I want to explain about why. So now we're talking about the Protection of Personal and Property Rights Act, and the basic principles of that act are a presumption of capacity. So hopefully you remember that capacity means understanding the nature and consequences of your decisions and being able to communicate them. So everyone is presumed to have capacity until they're deemed not to. And they're deemed not to by a judge. Now, judges don't know a lot about these sorts of things, so they rely heavily on medical evidence. But it's really important to realize that everyone is presumed to have capacity, so you're not automatically considered to lack capacity just because you have a certain IQ or because you have a certain diagnosis. It's always an individual assessment. The second important principle is the principle of maximizing decision-making capability. So you may remember that I said that the person that we're talking about here who may lack capacity is called the subject person. And so one of the basic principles of the Act is that you maximize the decision-making capacity of the subject person. A third principle is that any decisions made by a substitute decision maker must be made in the best interests and welfare of the person, of the subject person. So there is a list of things that they can't decide, but that's not limited to those things. They need to always be acting in the best interests and welfare of the person, and they mustn't act on any conflict of interest. Now, we're still talking about the PPR Act, the Protection of Personal and Property Rights Act, and that act also contains primary objectives. So the primary objectives are, and this is for the court to keep in mind, to only impose the least restrictive intervention possible to keep the person safe. So they should not be, the court should not be appointing a welfare guardian or a property manager or making any order at all unless they believe that it's absolutely necessary for the safety of the subject person. The second thing, and you may have noted that the first one about maximizing decision-making capability, that was one of the principles, and now this one as well, are the reasons that the government claims that supported decision-making exists in this law. So this one is to enable and encourage the subject person to exercise and develop such capacity as they already have to the greatest extent possible. So in other words, both the judge and anybody who's been appointed to a decision-making role are expected to consult the subject person, to encourage them to make their own decision as much as possible, to help them make the decision, and I assume to only make the decision on their behalf if they are unable to make it themselves. So in this way, and because of these rules, these principles and objectives, this is how it is claimed by some people that the Act actually accords with the Convention. Now, my biggest problem with all of this is that who's checking? And we don't have a public guardian like they have in Australia, although some people don't think a public guardian would help. Public guardian would be kind of like an age concern or a CIFS, a place where people could report concerns. And the public guardian would also be checking to make sure everything's okay. So that's the way I see it. That's one of the biggest problems. I'm not sure that there's a big difference between being an attorney under a power of attorney or being a welfare guardian. There's some people that say, oh, a power of attorney is better. Well, I guess it is better if the person is capable of deciding who should make decisions on their behalf. But you've probably heard as well as I have a lot of situations where people who are appointed as attorneys take advantage of that situation and steal money or neglect the person they're supposed to be looking after. So my view is that in these situations, either being appointed as a substitute decision maker by the court or by the subject person, either way you can carry out that role properly and use supported decision making and do it well, or you can also do it badly. So I'm not sure there's a big difference between those two. And there's no question that it's necessary to have something in place because it does happen that people lose capacity. So that's all I'm going to say in this video. The next video is about guardianship and welfare guardians, so we'll go into more detail about those. Guardianship is about children, and the purpose of talking about the two is to contrast them and talk about the differences between them. So thank you for listening, and I'll see you in the next video.